weekly roundtable discussion that takes place every Sunday at 5 p.m. Eastern Time. Tune in at 911warroom.com/Zoom.
Forgive me, I wanted to get this, if that's all right.
Yeah, I'm okay with it. If you end up making zillions of dollars showing this, feel free to share some with the Lawyers Committee.
10-4.
And by the way, since we are recording, and I am a lawyer, I will explain what some of you already know, which is, since you're not my clients, I can give you the outside scoop, but not the inside scoop on the case, because if I shared strategy and attorney-client confidences, I'd be waiving the privilege for my clients, and that would be a no-no for a lawyer. So I can't do that, but I can pretty much tell you everything you need to know to understand it from the public's point of view. And there's not much about the case that's confidential, so you're not going to miss much there except strategy discussions. So to put this in perspective, this case that Gene has asked me to talk about, as Gene said correctly, started with a petition to the federal grand jury, special grand jury in New York, Southern District. And it was detailed, documented regarding the demolition evidence that I expect you're all familiar with by now. And we relied heavily on the work of architects and engineers, other scientists like Kevin Ryan, Stephen Jones, go down the list. And we included a lot of hard science documentation, eyewitness reports from first responders. I think you know most of that. So it was a well-documented request. And all we were asking in the petition was not for the grand jury to do X, Y, or Z, or the U.S. attorney to do X, Y, or Z on the merits of the case. We were simply asking, please, U.S. attorney, deliver this to the grand jury and let the grand jury make up its own mind about what this evidence means and what federal crimes might need to be investigated and prosecuted. So as Gene said, the U.S. attorney sent us a letter, which Gene showed on your screen, hopefully. There it is. That said he would comply with the federal statute on which we were relying. And that federal statute basically says that a U.S. attorney, when receiving a report of a federal crime from citizens, must, I emphasize the word must, mandatory duty, report the information about the crime to the grand jury and the identity of the entity or person reporting it, which would be the Lawyers Committee in this case. And so it's something the U.S. attorney doesn't have the option to withhold from the grand jury. Now, that was our reading of the federal law. When we got the letter from the U.S. attorney, we thought at that time the U.S. attorney agreed with us. And it's really not in dispute, by the way, that this duty is mandatory. There's some dispute about exactly how much the U.S. attorney has to give to the grand jury. But I mean, the U.S. attorney may still want to dispute it, but the courts, even the court we're in, acknowledged that the duty is mandatory. That wasn't why we had to appeal. We'll get into that. So we waited for several months after we got the letter from the U.S. attorney, the Lawyers Committee did, and we thought we would hear something about progress on the grand jury receiving the petition and looking at the evidence. We did not. So Dave Meiswinkle and I called the U.S. attorney's office. We asked to speak to either of the gentlemen, assistant U.S. attorneys who had signed the letter to us. And one of them did pick up the phone and talk to us. And we said, we received your letter, thank you. We would like to know the status of our petition. Can you tell us whether the petition has been submitted to the grand jury and where things stand, and can we be of any help? And the assistant U.S. attorney said basically, no, I can't tell you any of that because of the federal rule of criminal procedure 6E, I believe it is, don't have it in front of me, which has a secrecy requirement for some things relating to the grand jury. And we said, well, we really need to know whether our petition has been given to the grand jury. Can you tell us anything or show us anything that would convince us that you've given the petition to the grand jury so that we won't have to bring a federal lawsuit to enforce the mandatory duty imposed by the statute? And the U.S. attorney, even though he was very professional and cordial about it, said, no, I can't tell you anything. which left us facing a dilemma. And as you know by now, we decided that the answer to that dilemma was to sue the U.S. Attorney to enforce the mandatory duty to give the petition, or at least the report of the crime and our identity, to the grand jury. So we did bring a 4-count complaint in the U.S. Federal Court, Southern District of New York. And the 4 counts, just in case you're not clear on the different theories we were using legally, the first one, we just asked for a release of grand jury records. And we didn't ask for all the records. I mean, we would have taken all of them, but we asked for anything that could be given to us that would inform us as to whether our petition was submitted to the grand jury. So that first count was simply asking, and by the way, we weren't asking the U.S. Attorney for this. We were asking the federal judge to release these records. So that's an important distinction to keep in mind. At this stage, it was no longer a decision for the U.S. Attorney to make. The federal judge has the authority to release those records, could have, in our view, should have, ended up choosing not to. So that was count 1. Now, count 2, see if I get my count straight here, was our First Amendment count. And most of you know that under the First Amendment, we all have the right to petition the government for a redress of grievances. So count 2 was basically saying, look, we have the right under the First Amendment to petition any government entity. And we decided to petition the grand jury, the U.S. Special Grand Jury. We also decided to petition the U.S. Attorney, but the fact that we petitioned the U.S. Attorney doesn't change the fact that we also petitioned the grand jury itself. And our argument here was simple, that the U.S. Attorney, by obstructing delivery of our petition to the grand jury, was obstructing our right to petition the grand jury. You know, whether the U.S. Attorney wanted to tell the grand jury to ignore our petition after he delivered it is another question. But he had to deliver it in order to avoid obstructing our right to petition the grand jury itself. And so that was our count 2. Count 3 and 4 were both what we call mandamus claims. Dean mentioned the concept of mandamus, which is simply a federal law concept that, and many states have it, that if a federal agency or official fails to perform a duty that is mandatory, not a discretionary optional duty, but a mandatory duty, then any citizen affected by the failure to do the duty can sue to enforce the duty, to compel performance of the duty. Now, there are 2 different laws, just for your future reference, in case you all decide to get in any litigation yourself down the road. 2 different laws you can use to do that. One of them is the federal mandamus statute itself, which is Title 28 of the U.S. Code, Section 1361. And if y'all need to actually read any of this law, feel free to ask me later, I'll send it to you. So 28 U.S.C. 1361 is the federal mandamus statute. It basically says what I just said, that a federal officer can be sued to compel them to perform a mandatory duty. Now, less commonly understood, although a lot of folks who do, who sue the federal government know this, the Administrative Procedures Act, which we call the APA for short, Title 5 of the U.S. Code, Section 702 and 706, which is also where the Freedom of Information Act is hiding, in case you didn't know. But that law also has a mandamus provision, which says that citizens can sue a federal agency for failing to perform a mandatory duty. So our counts 3 and 4 were basically asking the same relief, asking the federal judge to compel, to order the U.S. Attorney to give our petition to the grand jury under these 2 different legal bases.
Mick, can I interrupt you for one little sec? I just need to understand. So basically you were forced to go ahead and do this, even though it was technically possible that they had already delivered the petition to the grand jury, just that you didn't know for sure that they had because they wouldn't confirm it. Is that it?
That's pretty close to it. It is entirely possible, even sitting here today, although it's become less likely, that the U.S. Attorney actually did give our petition to the grand jury and we just don't know it. That is possible. It is based on how the government has argued their case, it's unlikely. But I'm inferring from their attempt to sort of have it both ways in their briefs to not disclose what they've done, but they've suggested, which may be a big hint as to what they have done, they suggested that they're reading the statute that to mean that they don't have to give the petition or the evidence to the grand jury just the fact that we have disclosed a crime, which I assume they would at least think would include the demolition of the buildings. So they may have given the grand jury one sentence that the lawyers committee has reported demolition of the buildings and felt that they complied with their duty. That's the way I'm reading what they said so far. They haven't come out and said that, admitted it, but that's my best inference. I don't actually know. We're still trying to find out. So if y'all have questions about something I'm talking about in the moment, you should not hesitate to interrupt me. I won't be offended. And particularly if it helps you understand as we go forward.
Thank you.
So, so we litigated these 4 counts in the district court. We briefed them. The court did not ask for oral argument on it. The court decided that on the request in count 1 for the grand jury records that, and it spent some time explaining this, that the court decided not to release any of those records because the court felt they were all covered by grand jury secrecy. We made several arguments to the contrary. And by the way, this count was not dismissed on a standing basis. We'll talk in a moment about the other counts and why they were dismissed on what we call standing grounds, meaning being eligible to sue. But that was not true for count 1. The court didn't decide we lacked standing to ask for the records. The court decided we were not entitled to the records under the secrecy requirements of federal law. Now, the basic argument the government made that the court adopted was that the Rule 6E, Federal Rules of Criminal Procedure secrecy requirement was broad enough to cover even what we call the ministerial records of the grand jury, meaning records that weren't about the testimony or the evidence, but just about procedure and what was happening in the process of the grand jury. We weren't even entitled to those according to the government, and the district court adopted that view. You should know that in the Ninth Circuit, which is out on the West Coast, and you probably know by now, federal courts, it's a strange concept, but federal courts don't apply exactly the same law everywhere in the country, even though federal statutes are the same everywhere in the country. If there's ambiguity, the courts have to interpret the statutes. And when there's not a statute, the courts have to decide what the law is. And same for the federal rules of procedure. And so in the Ninth Circuit, there is a rule that ministerial records of grand juries don't fall under the secrecy requirement. In the Second Circuit hasn't made up its mind on that question yet. And in other circuits, they've decided the ministerial records do fall under the secrecy requirement. So depending on where you live, you either will or won't get access to certain grand jury records. In our case, we don't know yet. And that's, and our case may be the one where the Second Circuit makes up its mind on that question of law and sets the law for the entire Second Circuit, which is in New York and other states. So that is, a work in progress. That is what our appeal is about. We don't know the answer on that yet. We have briefed the appeal, and we're waiting to see if oral argument will be scheduled. I expect it will be, but we don't know for sure. Now, on the other counts, the 3 other counts that were more on the merits, on the right to petition, the district court made a clear mistake in my view. It dismissed the right to petition count on the same grounds it dismissed the mandamus counts, on the theory that none of our plaintiffs, and let me remind you, hang on a second, if I can remind you. Maybe I can remind you, and maybe I can't remind you. So, okay, so the 2 mandamus counts were dismissed for lack of standing, and we had 8 plaintiffs, including some family members of 9/11 victims, first responders, Richard Gage, architects and engineers, lawyers committee, and the court decided that for our mandamus counts, even though we were right about the mandatory duty on the U.S. attorney to give at least the report of the crime to the grand jury and our identity as a reporter, the court decided we weren't eligible to enforce that duty. Maybe Congress could, maybe the president could, but we couldn't. And it wasn't clear who, if any citizens, would have the ability to enforce that duty. So the court didn't say, you're wrong about the U.S. attorney having this duty to do this. the court said we don't have the right to enforce it under the standing theory. Now, what has that got to do with our First Amendment right to petition the grand jury itself? And my argument is nothing at all. But the court decided we also didn't have the right to enforce our constitutional right to petition. You have to stop and think about that for a minute and let it sink in. What we're saying is that the Constitution gives us the right to petition for redress any government entity. The grand jury is a government entity. We sought to petition the grand jury. The U.S. attorney blocked it. So our right to petition has been violated by the U.S. attorney. Now, why wouldn't we have standing to enforce our own constitutional right to petition? And the court threw that count in basically in a footnote without much analysis into the same rationale that it dismissed the other mandamus counts on, that we weren't impacted enough personally. You know, if we had lost some money somehow by the denial of our petition, or if we were one of the suspects, we certainly would have had a right. You know, if the grand jury was looking at us as a culprit. But the court decided we weren't, individually affected enough differently from the public. And even for the First Amendment claim that we didn't have standing to bring it. And I think that's just wrong. It's to me, and we explained the law on this, that the federal courts have recognized certain statutes create essentially standing to enforce them. And you may not realize this, but the Southern District of New York federal court actually agreed. Oops, you just passed that, Gene. Back up a couple pages. One more. Stop. Oop. Well, you got a little reference to it there in the grand jury application. There's a site to it somewhere. This is a case back in the 80s by the Southern District of New York, U.S. District Court, the court we were in, which basically said we were right. I mean, it didn't know about our case, but it said citizens have the right to enforce the duty imposed on the U.S. attorney to report federal crimes to a grand jury. And it went through the legislative history of the grand jury's evolution and this federal statute that we're relying on that imposes the duty, and said, with a good rationale, this statute and the history of it and the grand jury show that citizens have standing to complain if their petition doesn't get submitted to the grand jury. So what the district court, the same district court and the same court that made this good decision said in our case was, oh, that case was just an outlier. It was disagreeing with itself basically from 20 years ago. But it didn't really explain, hang on a second, that is it right there. Zaleski, not the Zaleski. Zaleski is the case the government's arguing. Hang on, let me see. The problem is, oh no, you had it. So Zaleski is the Second Circuit case the government relies on. I'll tell you about that in a minute. But In re grand jury application is the case I'm relying on from the district court from the 80s, and it agreed with us. So the district court had to disagree with itself, one of its prior decisions, to rule against us. And to do that, it relied on this case you're showing there, Gene, Zaleski, which is a Second Circuit case. It was a Second Circuit case that was decided basically without any detailed analysis. And it was decided on different grounds under a different situation where a plaintiff without lawyers acting on their own, which isn't necessarily a bad thing depending on the case, but and some of these cases are technical enough, you may want to have a lawyer to improve your chances. In this case, the plaintiff did not have a lawyer, and he had not asked the U.S. attorney to submit his petition. He just complained after it, didn't happen. And there were other distinguishing factors, and there was a statement in that case in what we call dicta, which means it wasn't necessary to decide that case, which the government's relying on. And so it's essentially what I would call a perfunctory decision on distinguishable grounds in a case where the plaintiff unfortunately didn't have a lawyer to properly articulate their legal bases. And it didn't actually decide on, the point of our case, but the government's still relying on it. And we're going to find out what the Second Circuit thinks about that case in our appeal. So, so when the district court did rule against us on standing grounds on the 3 counts and on denying release of records on the 1 count, we did what Gene has pointed out and what we've been talking about. We appealed to the Second Circuit. You probably know there are 3 stages, 3 levels of the federal court system. You've got a district court where we started, which is the trial court. If you don't like that decision, you have the right to appeal to the mid-level, which is the U.S. Court of Appeals for your circuit, in this case, the Second Circuit, which is New York. And if you don't like that decision, even though you don't have a right to have your appeal heard as of right, you can petition the U.S. Supreme Court to hear your case, which is these days discretionary. It used to be you had a right to go to the U.S. Supreme Court. These days you don't. You have the right to ask permission to go to the U.S. Supreme Court, which is called a petition for certiorari. The court can say, no, we don't want to hear your case. And in fact, it does so in about 999 cases out of 1,000. So the odds of getting the Supreme Court to hear your case are pretty small. We're not there yet. And we hope that we're going to put the government in the position of trying to ask the Supreme Court by us winning this appeal. We don't know that yet. We have a strong case, but we can't predict the outcome yet. So we'll see about that. You probably know we do have one case on a petition for certiorari to the U.S. Supreme Court at the moment, which is our case against the FBI, the 9/11 Review Commission case. If you go back to the main page there at the top, if you can, to our website at the top, very top menu, right there, where it says FBI law, this FBI 9/11 suit, it actually should say FBI 9/11 Review Commission lawsuit. That's it. If you want to know about that case, you can go there. Short version on that is we're waiting to hear if the U.S. Supreme Court will hear our case. I'll give you the thumbnail on that. You didn't ask me to talk about that one, but
please do. Yes.
Well, I'll give you the short version. We sued the FBI because the Congress had mandated the FBI look at all the 9/11 evidence that the original 9/11 Commission had not looked at. And this was a lot of folks don't know about this. This was a mandate from Congress in 2013, and they renewed it in 2014, funded a study of about $1.5 million for the FBI to do what they called an independent review of all the 9/11 evidence. And the FBI created a 9/11 Review Commission, not to be confused with the original 9/11 Commission, headed by Ed Meese, former Attorney General. And they did basically a whitewash. They didn't look at any of the demolition evidence. They didn't look at the Saudi evidence. They didn't look at 5 other categories of evidence we put in front of them, including the high fivers and some other things. So we used similar legal theories, the mandamus, for example, to sue the FBI. They dismissed our case on similar grounds, standing. We appealed to the DC Circuit Court of Appeals, Federal Court of Appeals. That's the case where we had the interesting twist of our appeal panel of 3 judges, including Merrick Garland, who became the U.S. Attorney General just recently. So the person who became the head of the agency we were suing was on our appeal panel during the time of our lawsuit, suing the DOJ. You have to let that sink in for a minute. So, so during the time our appeal was pending, Merrick Garland participated in the early stages of our case. He didn't know yet, we presume, he was going to become the head of the agency we were suing. But it became public during our appeal that he was being considered as a candidate to become Attorney General. And even after public reports of that, he participated in a decision that took away our oral argument, which had already been scheduled, and basically led to the case being decided in what we call an unpublished decision, which gave it less public attention. So we ended up losing that case on standing grounds. And the final decision on the merits, there was a footnote that said Judge Garland did not participate in the final decision. We asked for a disclosure about his role in our case, and the court refused to give us any information. So that is now part of the petition to the U.S. Supreme Court. So I'll stop there and let you all ask any questions you might have.
Some basic questions I have, if you don't mind. In the original lawsuit, we're up to document, forgive me while I skip screens here. Yep. We were up to document 36. And once we started at the Second Circuit for appeals, it starts at 46. Could you explain what the gap is between 36 and 46?
I think you're on the second page of or third page of the Court of Appeals docket. You're going to have to download the entire docket. When you use Pacer, they will give you an option to get the most recent filings without charging you or charging you as much. And if you want the whole docket, you have to pay for the whole docket. It's a little bit more. And then you'll see that they start at number 1 in the Court of Appeals. You just don't have all those Court of Appeals filings yet.
Oh, okay.
So if you go for the full docket, I think that'll explain it. If it doesn't, I'll send you the whole thing and you'll understand.
Now I see it. Okay.
There you go.
Okay. And then there are some pockets like from 48 to 54.
That is curious, I will have to admit. A cure defective brief. That could be a clerk error, assuming that you have the docket from the webpage up. I haven't actually checked their numbering. I pay more attention to the substance of the entries, but
you're right. And like
the numbering
is missing.
That's normally does not happen, Gene.
Okay.
So I will check on my own and to give you the answer to that. And you may want to remind me in a couple of days to see if I can solve the mystery of the numbering.
Okay.
That's either a function of what the court is showing you, or it's a clerk error.
Yeah, there's definitely happens more than once through that list there.
The numbering should be sequential. There shouldn't be any gaps without an explanation. And there was nothing, to my knowledge, filed secretly in this case. And if it were filed secretly, even if it weren't shown to me, I would know that the filing was made.
Okay.
And generally speaking, it's kind of hard to file something without the attorneys at least seeing it. Occasionally you get a national security thing where they won't let even the attorneys see it. That would be, another lawsuit waiting to happen if it happens to us. That hasn't happened to us yet. It happens to other people in some cases. I've always found it a shocking thing.
Another would be, is the predominance of this just legal bickering going back and forth, catching you on certain forms that weren't filled out right or whatnot? Or...
Oh, you mean the different entries in the appeal?
Yeah.
If you've never done an appeal, and you probably haven't, for those of you who have the good fortune to not be a lawyer, when you do an appeal, the courts of appeals are pretty meticulous about their formatting standards, and they're not all the same. In this case, when we filed this appeal, we were thinking that our local counsel in the Southern District, John O'Kelly, who helped us with the case in the district court, would become my co-counsel in the Second Circuit. He was admitted to the second. You probably don't know this. I'm not a New York lawyer. I'm a Pennsylvania lawyer. And I do a lot of federal courts of appeals, but the Second Circuit was like one of 3 of the 14 courts of appeals that I'm not already admitted to. So I've done appeals in most of the other circuits, and I know their formatting requirements. This is my first appeal in the Second Circuit. So I was going to have a local New York lawyer help me with that, who's done appeals in the Second Circuit. Turns out the Second Circuit a few years ago changed their requirements to require anyone admitted to the Second Circuit, no matter how many years they'd been admitted, to renew their admission every so many years. And John O'Kelly had not caught that and hadn't renewed. So he wasn't immediately available to help me as co-counsel. We did a little sort of a quick search and couldn't come up with one quicker than I could just get admitted on my own. And so I got admitted for the purpose of this case only, which is called pro hoc vice, which meant I was left to figure out all the formatting requirements of the Second Circuit myself within the time frame for doing all this stuff without prior experience. Now, the court found a couple imperfections in my filings, which had to do with, let's see if I can remember. One had to do with, you're going to love this, pagination. Not only do you have to have the page numbers right, but they have to be searchable in the PDF so that when the court goes to find something in your table of contents, they can actually search in the page numbers and make sure that the page numbers in that search function matches your page numbers in your table of contents, which is not really a bad idea. It just takes a little prowess with PDF formatting to do it. So that was one of the errors. See if I can remember. These were non-substantive things, Gene. They were just formatting things.
Right.
I don't know if I can remember what a couple of the other ones were. One of them was a requirement that actually, and don't tell the court clerk I said this, one of them was actually a requirement of formatting imposed by the clerk that isn't actually in the rules. It's just the way they like to do things. And you want to keep the clerks happy, and we do. And they usually have pretty good ideas about formatting. It's not like they're illogical about it, But, if you don't get noticed, you don't do it. And then they tell you, and then you have to fix it. So that's what that stuff is about. Nothing of that is about substance, and nothing about it has to do with the merits or the ability to proceed with the appeal.
And is that standard operating procedure to get hung up on those kinds of details, or do you feel that they're just trying to, find every...
Yeah, it's a good question. My experience is that that's happened to me in other circuits, particularly the first time I've done things in other circuits. I didn't read too much into it, and they were pretty good about accepting what they call the cured version, the fixed version.
Okay.
And they also were pretty good about working through my admission request pro hoc vice, which means for the purpose of this case, even though I wasn't already admitted, they were pretty helpful in that. So no, I haven't seen anything irregular in their procedure.
Okay.
The Second Circuit at this point. Everything's gone according to plan, other than those formatting things, which actually is not a shock to any lawyer. I think the next step, which may be the next test, is whether they schedule oral argument. If they do, I think that means pretty much they're proceeding on course with the normal procedure. And then, after that, we'll just have to see what they decide. But I don't have any reason to be concerned with the Second Circuit at the moment. Their case law is fairly friendly to us on the issues we're appealing. We obviously are in a controversial area with 9/11, which shouldn't make a difference in how cases are decided. The law should just be applied objectively as it's written. And the law is fairly good for us on issues of like what we call informational standing for nonprofits. So like with the Lawyers Committee and Architects and Engineers, it's obviously central to both of our missions to promote transparency and accountability on 9/11, and in particular regarding the demolition evidence, which has been a major focus for both of our groups. And for the U.S. Attorney to fail to even deliver our petition on all that evidence to the grand jury is a major obstacle to us performing our missions. And the district court didn't buy that, but I believe the law is actually in our favor on the argument that gives us standing to enforce the duty. And, once we get past the standing threshold, there's nothing left really to litigate, because the duty is the duty. Mm-hmm. And the courts have basically acknowledged that duty exists. So they're going to have to basically rule for us if we get past standing. And that's why I think, I'm cautiously optimistic about the Second Circuit appeal.
I have a question about standing. Exhibit 22, William Rodriguez, and I've emailed a couple times. William Rodriguez and Philippe David were in the basement, were physically impacted by this. Philippe David, his skin hanging off his body. Would they not have evidence or standing, being that they're an exhibit?
No, they have to be named as a plaintiff to be at issue on the standing question. We did not name either of them as plaintiffs. We did name Robert McIlvain, for example, mm-hmm. and a few other family members. Bob lost his son at the Trade Center, probably based on the evidence we've seen, circumstantially, not having seen a grand jury investigation or an FBI investigation on this yet. The indications are that unfortunately Bob lost his son due to the demolition. Mm-hmm. It wasn't the airplane strikes, it was the demolition that killed his son.
Right.
So if he doesn't have standing, nobody's going to have standing.
Gotcha.
But how can he not have standing though? If the whole point of standing is to have, one of the plaintiffs be one of those that was directly affected by the events, then that fulfills all the requirements. No?
If I can say something, I would guess that if there were, let's say, a few 100,000 people outside the courtroom, he would have standing.
Well, it's not supposed to work that way, and we'll see, Patrick, whether it works that way. And lawyers aren't allowed to try to use external events to influence a court's decision. So that's not a strategy we can use. No. And what other people decide to do is, of course, up to them. Yeah. But
we decide that, but it doesn't mean we can do it. We want to do it.
Well, I don't know that that's going to change. My own view is, and this is me speaking just for myself, mm-hmm. not for the Lawyers Committee or any of the plaintiffs. My own view is that type of mass demonstration strategy is better targeted to Congress at the moment. There are a number of things Congress could do to fix this for us. They could pass a statute that just resolved the standing question, for example, if they chose to. Now, but let me get back to the question that, all of you are basically asking, and I see that the giraffe is wondering about it there too, in Loren's background. It looks very, very contemplative and concerned about it. The short version is there's a distinction, and maybe there shouldn't be a distinction, but the courts are making a distinction between who was affected by the underlying events, and they're not really saying that Bob McIlvaine wasn't affected. They're not saying that by the underlying events. What they're saying is Bob McIlvaine wasn't sufficiently legally affected by the obstruction of the delivery of our petition to the grand jury. They're not saying he didn't have a personal loss in the underlying events. So if we were suing for Bob McIlvaine, like in the Saudi case, where the big law firms are suing for all the families against the Saudis in federal court in New York right now, saying, look, all these families lost family members and someone should have to pay them financial damages for those losses. That's a different type of legal theory. We're not asking in the Saudi case, to my knowledge, for a mandamus to force the U.S. attorney or the FBI to do something. They might want to give that some thought, actually, but they haven't gone there yet. But they're asking for money damages for losses of family members. And if we had brought that type of claim, we would have standing. Bob McIlvaine would have standing. Now, to bring, and by the way, I think we had standing for the claims we did bring. We just got a bad decision. But if we had the financial resources of the big law firms doing the Saudi case, we would bring a case like that. And we would have standing, and we'd get past the initial threshold, and we would get to the evidence. And one of these days, we ever get that level of resources, and we don't have it at the moment, you might see us doing that. There is a solution to the standing problem for some types of claims where the courts just can't get around it. And the Saudi case is one. And there are others we're going to be talking about in the Lawyers Committee coming up. In our, I don't know if you remember, but we announced we're going to be revisiting our mission over the next few weeks and deciding our new strategies. I can't tell you what those are yet because we don't know. But when we figure it out, we'll let you know. And one of those strategies could be bringing a lawsuit where standing is not an issue. The only way to do that, though, is to have the resources to do it. And that means either you have attorneys willing to volunteer, basically full time to work on the cases and someone to front the expenses, or you've raised, a couple $100,000 or more, which we haven't done yet. Okay, so other questions?
Is the Campbell family a part of this? Has anybody been in touch with them from England?
We are in touch with Matt Campbell's family. Matt was not a plaintiff in this particular lawsuit. And he has now a very interesting, as you know, complaint in the British system to reopen the inquest about the loss of his brother, I believe it was. And that is analogous to what we're doing in New York under a different legal system in Great Britain. And it'll be fascinating to see what they do with it.
Yeah, they have different conditions, though. They just have to prove that there is a reasonable doubt about what brought down the towers, right? I mean, I think that everything hinges on that, if I understood that correctly.
Well, I can't give you legal advice on British law, not being a British lawyer, but that's what I understood his lawyer to say.
Mm-hmm. Interesting.
Yeah.
If I could ask back on this for document 58 and 60, oral arguments. Attorney Alexander Hogan made an oral argument, and then you made an oral argument.
No,
what
that's not correct. That's not correct. And what you just said is perfectly logical. It just happens to be incorrect. And the reason is oral argument statement is a term of art under the rules, and it has nothing to do with presenting oral argument. What it has to do with is telling the court whether you wish to have the opportunity to present oral argument. And so the government took a position and we took a position. I believe the government took no position. I'll have to go back and look at it. In other words, they didn't say we insist on oral argument or we don't want it. I think they took a sort of a, no comment position, and we said we want oral argument. No, those are the two statements, but the court now has to. the court has to decide whether to give us oral argument. And the court doesn't have to do that under its rules, but it may.
So when people say, I hear all the detractors online saying, oh, the Lawyers Committee is not doing anything. Right here, you can see as of September, you're very much doing stuff. Right up until the day before 9/11, things are happening. So,
well, we are doing things. There's one thing that folks may not have picked up on in the, what would be the word, the activity surrounding the anniversary. But on the anniversary, the 20th anniversary, we filed a new document on the 2001 post 9/11 anthrax attacks, which if you don't know by now, we consider connected to the 9/11 attacks. And it's not up. Oh, hang on, stop right there. Dean, let me look. Move your cursor so I can see the whole top menu. Okay, there. It's not up yet. So probably by tomorrow, you're going to see another item listed there in the top menu. And it's going, instead of, and in addition to saying anthrax congressional petition, it's going to say anthrax federal grand jury petition. So we've filed a related document. It's more detailed than the congressional petition. It's lengthy. I forget what it turned out to be, 150 pages or something. It's well documented. It covers a lot of the same evidence as in the congressional petition, but it goes through the federal laws. It's more of a guide to a grand jury than a request to Congress, but it's on the anthrax attacks. And so we filed that actually less than a month ago on September 11th. So yeah, we're still very active doing detailed legal and investigative filings within the limits of our resources. And if someone says we're not doing things, I would basically ask them two questions. One is, are you following what we're doing? And the other is, you know, what are you doing, and who else is doing more than we're doing? And I hope someone else is doing more than we're doing, and more power to them. I haven't seen that at the moment, unfortunately. Architects and engineers are doing things. You may or may not know, you probably do, that architects and engineers filed a lawsuit also probably within the last 30 days against NIST. I'm their lawyer in that lawsuit, along with John Clifford, an attorney in DC who helps me on some of our freedom of information cases. And while we're talking about things we're doing, it may have gotten lost in the shuffle on these other things, that we have a freedom of information lawsuit that we appear to be winning, which folks who are wanting to say we're not doing anything probably aren't tracking. And that is a lawsuit we did for David Cole. Many of you know David Cole. He has done a lot of the prior FOIA work, the Freedom of Information Act work. He did a lawsuit, and I'm his lawyer in it, against NIST and against FEMA about the building performance study done by FEMA on the Trade Center collapses. And he had first made the request for all their data. And this is one of those, like, you know, you just shake your head when you hear the story here. The first thing they told him when he requested the data was, we don't have any records. And you have to stop and think about this. They did a detailed study and published it on the building collapses of the Trade Center, called the Building Performance Study. But when he asked for all the data they used, they said, we don't have any records that respond to your request. So that was just a head shaker. And so, you know, when David brought the case to me, I said, well, you know, that sounds like a good one. So we decided to sue. And the next answer they gave, I think just before we decided to sue them, was, well, we did have records, but FEMA gave all of our records to NIST so that NIST could use them for their follow-on studies, like the NIST studies that AE is challenging. And I shook my head at that too, because you can share your information with another agency if you want, but there are federal record statutes which, you know, don't allow you to destroy your records. And even if you wanted to, how would you give another agency or entity everything you had? You have to give them all your hard drives, all your desktops, all of your backup storage systems, all your emails, and ever email backup. I mean, how do you get rid of all your records? You'd have to work really hard at it, and there'd be no rational reason to do that. So we didn't believe that either. So we sued them, and shortly after we sued them, they coughed up a big chunk of those records. And then they didn't give us the ones that seemed the most significant and claimed they couldn't find them, even though some of them were referred to in their own studies. And so the judge, the judge has to be more circumspect and, professional about these things, but he was sort of subtly shaking his head when he heard these stories. And at one point where they promised us they would go and search, what did they call it? They called it a warehouse archive to see if they could find some of the missing records. We said, yeah, go ahead and do that. We'd love you to look. And then they came back and said, oh, our mistake, that warehouse doesn't exist.
Wow.
And, the judge we did have our oral argument in that case early, and the judge said, that's going to be hard for the agency to walk that one back. And so he basically, first of all, he was thinking about giving us discovery on the case up front because of all these irregularities, and probably should have, but he decided, in an abundance of caution, because of the case law, to require both sides to file a summary judgment motion, which is normally how FOIA cases are decided. And again, for those of you non-lawyers, a summary judgment is a prelude to a trial, which may eliminate the need for a trial. And so if you file motions and it turns out there are no real facts in dispute, but the case can be decided on undisputed facts based on just applying the law to it, you don't need a trial to do that. The trial is for deciding disputed facts where you hear competing evidence and decide what the facts are. But if the facts aren't in dispute, you don't need a trial. And that deciding those cases at that stage is called summary judgment. So we filed our motions, and we also renewed our request for discovery when we filed our motion. And what the court did was we have a senior judge there, Judge Emmett Sullivan, who impressed me as quite excellent. He assigned the summary judgment motions to a magistrate judge to decide, which a lot of judges do. And then the magistrate judge makes a recommendation back to the trial judge, and then the judge decides the case. So the magistrate looked at what we filed, and he made two recommended rulings. One was that the government's summary judgment motion be denied. So let that sink in a minute. What does it mean for the government's summary judgment motion to be denied? It means they cannot win on undisputed facts, which means the best they could hope for in this case was to go to trial, a public trial where the evidence would be put forward in a public setting. So that's the best the government has looked forward to, in my view, at the moment in this case, which is not something I don't think they're going to be excited about, because you're normally not going to get to a trial without having to do discovery, which means we get to depose their people, subpoena their records, and so forth to figure out what happened to these missing records. Now, the other decision the magistrate judge made was to recommend that our motion for discovery be granted. So we're now on the verge of maybe being the first 9/11 case, with the exception of some of the jurisdictional discovery done in the Saudi case, to get to discovery, and where we actually get to force records to be released by the agency we're suing. So we're on the verge of winning that case. We hope. We can't promise it. It's been pending before the judge for a long time, and we may have to make a tactful motion to remind the judge that we would like a decision, and that's where we're at on that. So just for folks who think we're sitting around, twiddling our thumbs, we are doing some things, and we're making some progress. I'm not ready to tell anyone that litigation is the be all and end all of 9/11 strategies. That is not what we're saying. Mm-hmm. Our position was, when we started 5 or so years ago, 6 years ago, maybe now, the Lawyers Committee, almost 6 years, was that federal civil litigation strategies had not been used fully to test the courts on 9/11 issues. And that's something that needed to be done, and that we identified some strategies that had potential, and we weren't prepared to just assume they weren't going to work. We thought they had to be tried. And so we're trying them. And we didn't promise anyone they were a panacea. What we basically were saying was, look, you have to try these things because they might work. The law says they could work, maybe should work. And, we're not going to feel good about ourselves if we never try them. Mm-hmm. But you don't give up your other strategies in the meantime. Investigative strategies, media strategies, congressional strategies, direct action strategies. I come from a history of, I started out my career with the Government Accountability Project in DC, a nonprofit that represents whistleblowers. And we used a campaign approach by design, which recognizes that litigation isn't the only strategy that can solve your problem. So you use all these different strategies that I just mentioned in what you think is an intelligent combination for the problem you're trying to solve. And some strategies work better on some problems. And that's what we're doing. And we don't know yet how much success we're going to have. The initial decisions on standing are discouraging, but they probably don't comport with the law. And whether the Court of Appeals in the Second Circuit jumps on the no standing bandwagon or joins us and saying, yeah, sure, the family members and the organizations have standing. The question is, are they right on the merits? And that's what the court should be doing, looking at the evidence, looking at the law, and not just shutting us out on a technicality. So it's early yet to say, if someone says, well, we should give up on the litigation strategy because the lawyers committee hasn't won anything meaningful yet, that decision is premature. But we might be there in a couple of years or not. We'll have to see. Hope we're not. And if we are, we're going to be the first ones to say, let's look at some other strategies. And we're actually exploring some, of course. Our grand jury petitions are not a civil litigation strategy. They lead to some civil litigation, but they're more of an advocacy strategy and an investigative strategy, getting the truth out, whether the government wants to address it or not.
Yeah, I've heard Barbara say that part of the strategy was not necessarily, to get to the justice point or get everything we want, but to have these things on record in the system, so that eventually, even if it was lost in the end, it would be there to be found in the history of the legal system and available for anybody who was looking for it.
That's at a minimum. Something we are accomplishing is creating for posterity a record of the truth and of how the FBI, the U.S. attorneys, the Congress have or haven't dealt with the problems. That's important. And Dave Meiswinkle, one of his big points, which I agreed with, was, I don't know if we're going to win these cases, but we need to do the right thing. We need to put on the record what the right thing is. We need to put on the record what the truth is. And at least our children and grandchildren will know.
Right.
And we've done that. That's an accomplishment. I hope that's not the only thing we accomplish, because that's not what our primary purpose.
Obviously, yeah. I guess my question to you, I know that you're the lawyers committee, and you're a very restricted field of knowledge and talents and professional backgrounds. But I guess my question would be, how can we help? What can we do? Is there anything at all that would make a difference at all? Aside from financial support, which you mentioned, which is obvious,
Right.
But as, grassroots lone wolf activists who just would like to move anything forward, is there anything at all that we can do?
Like the lone gunman. So I think helping us think about strategies with Congress is important. Let me give you a concrete example. Our 9/11 Review Commission case, which I told you about a moment ago, that's now before the U.S. Supreme Court, hoping that the U.S. Supreme Court will decide to hear the case. This is on the congressional mandate to look at all the 9/11 evidence. Make sure you understand what I'm saying about what happened in this case. What we were trying to do in that case was not to try to get the agencies to do something that we just decided was important to do. We were trying to enforce a congressional mandate to the FBI. Okay, it wasn't us who told the FBI that they should be looking at this evidence. The Congress told the FBI that they had to look at this evidence, and they funded it. Okay, and what the district court said was, well, there wasn't any actual requirement, even though the Congress paid $1.5 million for the study. There wasn't any requirement for the FBI to report back to anyone on what they found, including to Congress itself. You have to think about that for a minute. Congress funded a requirement for the FBI to do an independent review of all the evidence on 9/11, and the district court said the FBI didn't have to report that back even to Congress. Okay, now that doesn't make any common sense, and some aspects of the law are not common sense. They get technical, but the technical hook the district court relied on was that in the congressional funding statute, where Congress decided in their wisdom to put this mandate, which they shouldn't have done, they should have put it in another substantive statute, like the anti-terrorism statute or something. But instead, they put it in a funding bill. And it was fairly cryptic. It said, you know, the FBI needs to do a comprehensive review of 9/11 to address X, but it didn't spell out everything that Congress expected in the actual bill, the statute. But in a Senate report, which was given the status of a joint committee of Congress, which means when the two houses are trying to get on the same page on a bill and they confer and they come up and they explain what they were thinking in the language that ends up getting proposed and enacted, which is the most powerful legislative history you can have to explain what Congress intended in a bill. The Senate report, which I'm about to tell you about, was given the status of a joint committee of Congress, and was given that status by a vote of the entire Congress in passing this funding bill. And what did that Senate report say? It said, in this report, we're requiring this new independent review we're requiring of the FBI. We want the FBI to do A, B, C, D, E. I think there were several requirements. I forget how many, maybe 7. One of them was explicitly stated in the Senate report to assess all evidence regarding 9/11 that relates in any way to the attacks that was not originally assessed by the original 9/11 Commission. It's not ambiguous. It's very detailed. It just wasn't in the language of the Congressional Act. It was in the Senate report explaining what they meant in the Congressional Act. And what the court said was, we don't have to look at legislative history, even though it's abundantly clear, because it isn't in the language of the statute, of the funding bill. That's how technical it gets sometimes. Now, and unfortunately, the DC U.S. Court of Appeals, which had Merrick Garland on the panel for a time, decided to agree with them, agree with the district court on that, which is completely wrong. Okay, now, even though it was wrong and we should have won that case, that is fixable by Congress, because this is something Congress wanted for all the evidence to be assessed. They think they got what they paid for, because that's what the FBI and Ed Meese told them. Yeah. They didn't. So if you all help them understand they didn't get what they paid for, and the way to fix it is to reenact that mandate in like the terrorism statute or some other substantive statute, and put the details in the language of the statute itself, so the courts don't have to go to legislative history to figure out what they want, we won't have this problem next time. So if citizens can organize to help Congress people decide how to better get what the Congress itself has already decided it wants, not what we want, what Congress has already decided it wants, which is an independent assessment of all the 9/11 evidence, this problem can be solved. And that's not a litigation strategy.
And can you give us a bit more of a practical breakdown of what that would look like? How exactly?
Well, we're going to draft a proposed statute. It's only going to be like a page with the language that basically takes the language from the prior legislative history and puts it in language for a proposed statute.
Right.
And then what citizens would have to do would be to take it to their representatives and senators who voted for the initial funding bill that had that mandate in it, and who signed on to that legislative history, and say, and just explain to them, maybe with a 5 or 10 page report, here's why you didn't get what you asked for.
Right.
Here's why we weren't able to enforce it. Here's all you need to do to fix it.
Right.
Pass this new language. And then you have to do the political thing, which I can't help you with that part.
Now,
right.
I'm from Pennsylvania, and I've repeatedly emailed, written letters, and called Senator Casey and Senator Toomey, and they have not responded once to my 9/11 calls, phone calls, letters. It's very frustrating.
Yeah, I know it is. I think that is a solvable problem, and we probably need to organize family members, more of the family members, to help us, and have a pitch made by the family members for this. I mean, one of the 7 categories of evidence in our case that the FBI Ed Meese 9/11 Review Commission ignored was the Saudi evidence. So this is another vehicle for the families in the Saudi case to get what they want, which is still being hidden from them. I mean, they're still trying to get it the hard way, which is getting the court to order the FBI to cough it up, or the DOJ to cough it up, and even the Biden administration, notwithstanding their gradual, what would be the word, inch by inch release of documents under the new order, executive order. They are releasing some things, but they're not, they haven't given it all up, and they're not going to give it all up unless they're forced to. Congress could force that through this new law we're talking about, and would help the families in their Saudi case. And, the families and the big law firms funding the Saudi case could help us with this campaign if they wanted to.
Are you in touch with the people handling the Saudi case at all?
Not to speak of. And let me just say without elaborating, that's by their choice.
Okay.
So if I may real quick, because this is one of the points I wanted to make, I'm trying to get a list of current legal avenues going on right now. And I realize now that you're talking about things progressing in certain FOIA lawsuits, there's more to it than this. But in general, we have the big Lawyers Committee grand jury petition. 2, we have, well, I'm going to do these. I'll keep them in order. Architects and engineers for 9/11 Truth are behind 4. The congressional investigation, that's the big petition. They always ask people to sign their petition. That's theirs. The Bobby McIlvaine World Trade Center investigation draft legislation. AE 9/11 Truth has now filed a lawsuit against NIST for a request for correction. AE and the LC are doing the FBI lawsuit, which is now that fancy word going to the Supreme Court. And the Lawyers Committee is pursuing things with the anthrax petition to Congress. We have Jeff Campbell's lawsuit in the UK. And then the 2 other I'm written in here, the Guantanamo 5 going on right now, I guess, Guantanamo Bay, and then the Josta lawsuit with Motley Rice and all those. Is that a good general list?
I don't think you mentioned, and I think you probably are thinking you mentioned, but the case we came to talk about today is actually not on your list the way you listed it.
So that's the first one.
Well, but it's, you're thinking of the grand jury petition. You're not talking about AE's own petition like to Congress. You're talking about the grand jury petition in New York.
That was the first one, yes.
Okay, so that one is now before the Second Circuit, and with that clarification, then that one is on your list.
Yep.
And then the FOIA case we talked about probably should be added in DC against FEMA.
Oh, yes. FOIA, FEMA. Okay.
The anthrax thing has 2 components. It has a congressional petition and a grand jury petition now.
Okay, yep.
Let me make sure I'm not missing something myself. We have, this is not active litigation yet, but we have investigative projects that are active primarily on government misconduct. It's not finished yet, hasn't led to a filing yet, meaning 9/11 related to government misconduct. Mm-hmm. We'll tell you more about that as it progresses. That could become a new grand jury thing, could become a new federal civil lawsuit. It could become the type of lawsuit that I mentioned to you that would solve the standing problem. But if we do it, it would only become that if we generate the resources to do it. Otherwise, someone else would have to do it. There is a legal theory, which I won't go into in the moment, because we haven't talked it through within our organization, that I believe is available to family members that has yet to be tried, including in the Saudi case, that would solve the standing problem and would go to the heart of government misconduct and government cover-up on 9/11. And we're exploring that. If we generate the resources to do it, you'll be hearing more from us on it. If we don't generate those resources, and that we may know that by the end of the year, because we're about to do a new fundraising campaign, which that'll be a part of. If we fail in that, we're probably going to discuss it publicly and essentially turn it over to whoever else can fund it, because we won't be able to do it. And the question is, who would be willing to do it? Who has the funding to do it? I don't know the immediate answer to that.
And the last thing I wanted to ask for, I'll turn it over to everybody else. David Cole had helped me file this FOIA request. You chimed in at the end and said, I would not include the within 1 mile of the Pentagon because you're getting a little too restrictive there. And we ended up filing it that way anyways. And that kind of bit us in the butt because they wrote back, there is an additional footage, approximately 100 videos. However, this material has not been reviewed. So that we have them on the hook for these 100 unreviewed videos.
Right.
I was just talking with David Cole, I think yesterday, and said, I'm thinking of refiling this, asking for those specific approximate 100 videos. And I just wanted to get your opinion on that. Does that
make sense to me?
Okay.
I think you need to do a couple things, or we together need to, and that would be to ask for the videos they identify that they haven't reviewed in a separate request, and then to ask for videos that, how shall I say, we'll have to think about the wording, but that are not limited to being within 1 mile of the Pentagon, but that show or are thought to show or purport to show any approaching aircraft on 9/11 approaching the Pentagon, yes, or departing the Pentagon.
Because the original 2006 request from Scott Bingham, most of the videos weren't around the Pentagon for those 85 videos.
Interesting.
But those were reviewed. So these 100 have to be outside of those original 85 from Scott Bingham's.
Well, I find that disturbingly confusing. I don't know why that would be, but we need to find out.
Yes.
But by the way, you've identified an example here, Gene, of something that Congress didn't get, that it thought it got and thought it paid for in the 9/11 Review Commission, which is looking at all the 9/11 evidence. One of our categories was Pentagon-related photographs and videos in our 9/11 Review Commission lawsuit, now before the U.S. Supreme Court. That was one of our 7 categories. This shows if they haven't been reviewed, then Ed Meese's commission didn't look at them either.
So the Department of Justice, their responsibility was to present this evidence to the 9/11 Commission as well as Congress, and they did not.
That's my read. And the 9/11 Commission had the responsibility to ask for it, and they maybe thought they did ask for it. They clearly didn't get it, or these would have been reviewed.
Yes.
The date on this is 2018. The commission finished its work in 2015.
All right. So, thank you.
Yeah.
Anyone else?
All right, folks.
That's amazing. Has there historically ever been any cases similar to what we're dealing with? I mean, just for edification purposes.
Well, you might want to be a little more explicit when you say anything like we're dealing with. Give me a little more detail. You mean like a big cover-up, government cover-up?
Yeah, I mean, where you're going, for a grand jury hearing and going to the appeals court and then having suffered the same issues.
Understood.
So that's kind of what I was getting at.
Okay, so on the grand jury litigation that's now in the Second Circuit, there are a few cases where plaintiffs who petitioned a U.S. attorney or attempted to petition a grand jury ended up suing to enforce the mandatory duty we're talking about in different jurisdictions around the country. There are a few of those cases. Most of those cases erroneously decided either the plaintiffs didn't have standing to enforce the duty that actually exists, and there are actually a couple of them, I think, that said the court didn't believe the duty was mandatory, which is just wrong. Okay. There's no real ambiguity about that in the statute, and the DC Circuit and I think even the Second Circuit have decided the duty is mandatory. So I don't know the Supreme Court has had to come to grips with that yet, and they will be the ultimate arbiter of it. But Congress made it clear it's mandatory. So if the courts say no, the Congress is going to have to fix it again because the court screwed up something that Congress made clear. The courts aren't supposed to do that. The courts don't have the power to rewrite the statutes. It's called the separation of powers concept in the Constitution. The courts have the powers to interpret ambiguity, but they have to honor what the Congress decides. And so if it's not ambiguous, the courts just have to enforce it. And that law is established. The courts just don't always do the right thing on what's ambiguous. So there are some lower level cases out there. There's a case in the DC Circuit where the court found that the plaintiff there didn't have standing to enforce this duty, but it's sort of distinguished from our case in some ways. The Second Circuit case I mentioned is distinguished from our case. So there's not a lot of litigation on it. It's an evolving issue, and our case may be the one that makes the law clear on it, at least in the Second Circuit, and other courts may follow if we get a good decision from the Second Circuit. And I think they should just follow what the Southern District of New York decided in the 80s, which was pretty straightforward, which is, yeah, citizens who petition have standing to enforce the duty on the U.S. attorney if the U.S. attorney doesn't honor the duty. It's not really, in my view, it's not legal brain surgery, what we're talking about here. It's a clear duty, and there ought to be clear standing, because if you don't give citizens who petition the standing to enforce it, basically nobody but the federal government itself can enforce it. And then it's not really a meaningful duty, because the duty isn't about what the U.S. attorney does when Congress asks the U.S. attorney to do something. The duty is about what the U.S. attorney does when a citizen asks the Congress to do something. And so the entity affected by that failure would be the citizen. And so they're the ones who should have standing. The courts have been stingy on standing over the last few decades. You've seen it in environmental cases and in other, maybe civil rights cases, other public interest cases. The New York Times, I think, had an editorial at one point that said standing is being used as a weapon to keep, public interest plaintiffs out of court or citizens out of court. It shouldn't be that way. It may be that way by certain judges. And if it is, then that's a problem that needs to be fixed.
Interesting. One final question from me. With David resigning, is that hurting the lawyers committee in any serious way, or is somebody going to fill in for him? Or I guess I don't. I mean, my reaction was, that it might have done some damage to the lawyers there.
Well, I can't. I guess we don't. I guess history will probably answer your question.
Yeah.
But anytime you lose, one of your board members or one of your executive staff, it doesn't strengthen your organization, generally speaking. But David was. Folks don't necessarily realize this, sort of wearing three hats at the same time, and that happened by historical accident because we were short-staffed, and so he was. The chair of the board, the president of the board, and the executive director at the same time. I'm going to speak for myself now and nobody else. I believe in a flat organizational structure and a democratic organizational structure. I don't believe in consolidating power in one person. And I believe nonprofits, particularly those trying to enforce the law like we are, should walk the walk of democracy and not just talk the talk of democracy. So I was an advocate for spreading duties around, and that's what we've now done. And David was offered one of those key positions as president of the board and head of outreach, and he declined. I'm now the executive director, but I will tell you that I've only committed to do that for 3 months, and that's because I'm still doing the litigation for the lawyers committee. I've given up the title of litigation director, but I'm still having to do the lawsuits. So I don't believe that anyone should be doing both of those jobs. I mean, I'm doing them out of necessity, which is sort of like your question, is anyone covering? That's one of the ways we're covering. And then Jane Clark is now chair of the board. So we have the positions covered, but we don't have a structure, in my view, that's sustainable in the long term, because we need more lawyers and we need more funding. So after December 31st, I hope we have a new executive director. I don't think it's sustainable for me to do both those jobs. I think we can cover until then. We're not immediately, how would be the word, obstructed in performing our jobs, but we need to find a fix. And the fix is simple. And I blame, basically the bar, meaning all those other attorneys out there who aren't getting involved, we need more help from more attorneys than we're getting. And it's a bit of a challenge for attorneys to take on a task like this because of all the propaganda trying to discredit conspiracy theorists, which, people like to call us, even though we're clearly evidence and law-based organization run by lawyers and investigators and technical, scientific folks. We don't put out a theory unless we can prove it, which is why we have a limited number of public positions. And some folks are unhappy with us not taking more positions, but when we get around to doing our investigation of those things, we'll take those positions as well, but not until we can prove them. So we need other lawyers to understand that we are that type of organization and not to shy away from us because of the propaganda campaign that try to paint everyone dealing with 9/11 with a broad brush. And, the public interest lawyers out there are really falling prey to that propaganda campaign. And it's contrary to their own values. And they don't realize it probably. But, and it'd be nice if some of the big firms that are doing like the Saudi case would get involved with us and help us do some of our strategies and fund them because they can afford to fund them. And we may be getting close to that. I mean, it was a step, and I'll give credit to the firms, the Motley Rice and the other firms doing the Saudi case to have the courage to do that case. But they also have a big incentive, which I'm pretty sure, I could be wrong, and I'd be delighted for them to say, we're not charging anything, but I think they're probably on a contingency fee. I don't actually know that, which means if the Saudis cough up billions of dollars, Motley is going to make out pretty good on that case. Now, if they're going to donate all that money, I'll be standing up and applauding them for that. I hope that either they've committed or they're thinking about doing that. I do think they have a public interest motive in doing that case. I just don't know if they've given up their financial incentive.
Could Sandra and I work with you on creating maybe a flyer or a mailer that we as street activists could approach lawyers looking to talk to you about helping out?
And do they have to be Canadian, by the way? Do they have to be American, or can they also be Canadian?
They don't have to be American to help.
Okay.
They could be British, Canadian, they could be anything. They could be German. But to appear in a case, they'd have to be admitted to a U.S. court. And the easiest way is for them to already be practicing in the U.S. There are some foreign lawyers who do that. So to answer your question, Gene, first of all, I appreciate the offer. I think we should probably have you join one of our board meetings and talk to us about things you're thinking of maybe you could do to help. This is not a decision for me to make personally. The board should approve it. It's a little delicate depending on what you all decide to do. I think there probably is a role where you could help us. And I think ultimately when the first contact is made to our citizens, so, if we had family members who would join some of the lawyers in approaching other lawyers, folks like yourself who are committed activists on the issue, whether family members or not, or victims or not, I think that's a good thing. I think it should be a team thing. And I think we should outline an approach before we do it and get approval from our board and any other entities you think should be involved, including your folks. And let's see if we can do it.
Excellent. Speaking of funding, is there any?
It's a legitimate question. We actually got approached once by folks from Iran, I believe it was, and we declined. They didn't offer us a lot of money, but they were interested in talking to us about maybe even representing them, which we declined. Iran is, you may not realize, Iran is sort of involved in some of that litigation. They probably shouldn't be, but they are. The Saudis would have to believe that the sword has to do with evidence pointing to the Saudis. So we haven't finished an investigation